Just kidding. Thank you. And then we use tribunal here.
My apologies. My apologies. My apologies. Good morning, Honorable Tribunal. My name is Chizoba Noelo, a citizen of Nigeria. I am a tax analyst.
Your position in the company?
My position in the company is a senior tax analyst for Uber BV.
Hold on. Sorry, this is Chizoba.
Yes, sir.
Miss or Mrs.?
Mrs.
Mrs.
Yes, sir.
Chizoba.
Nonyelo.
And what's the surname?
Nonyelo. Nonyelo. Yes, sir.
You are the representative of the appellant.
Yes. Yes, sir.
Okay. What's your position in the company?
Senior tax analyst.
That's all we need you for now. Thank you. Get back here.
Okay,
so, Thompson, who appears? Oh, sorry, the respondent has the representative. Yes, sir. Good morning. What's your name? My name is Chicken Jacob. Which one is Jennifer? What's your position? Deputy Manager Tax. International Tax Department. NRS. Correct, sir. Yes, Learning Council. Right, yes.
With profound respect to this honorable tribunal, my name is Festus Onyina.
Okay, hello.
Look, I appear for the appellant and I appear with my learned colleagues. Mene Josiah.
Mr.
Mene Josiah is a company name. Mene Josiah. Yes, that's Josiah. Josiah. Yes. And O Olaiwola. We appear for the appellant. Thank you.
Appearing with new bottom. And they do say, give me fair. And when you hear blood,
yes.
Yes.
What's the position?
The matter was adjourned to today for hearing of the substantive suit. Pursuant to an earlier order made by this tribunal for the witness to be heard virtually. The witness is available virtually, and we are ready. I should mention, sir, that we have a housekeeping application.
That application is not a house. That's why I'm surprised.
Well, we have an application for leave of the tribunal to file and rely on a rejoinder. This application was presented and filed on the 4th day of May 2026. We rely on the rejoinder and an additional witness statement.
Well, you're not moving it yet. You're still telling us where it is.
I'm just trying to identify.
Well, your colleagues haven't responded. We need to know whether they will respond. I think filing something, whether they object to it. So, they will be the ones to tell us again. I'm going to look for them. Yes, Ms. Lorena. What's your reaction?
Yes, Mr. Chairman. We received the application just given to us yesterday. Yeah. Ordinarily, we will not have a problem with this application. Yeah. However, it's important that I bring to the notice of the tribunal what was found. If the tribunal and look at the document, forgetting the name of this is more of a regular document, like a final written address. This letter.
Yes, that's why I'm asking, do you want time, because since you're entitled to time to react, you want time to respond? Because we're supposed to respond, you're right to respond.
We might need time to respond. Yes, Mr. Chairman. Don't have a problem with the additional written documents. Additional statement of votes. But the rejoinder is not known to the rules of this tribunal.
Which is why we said, if you want to respond.
As a tribunal basis, we will look at it, but we don't want to create a situation what that would drag this matter any further than it should.
So if they just have been, yes, I can.
As a tribunal basis,
Then, just, okay. Then, I mean, probably it's your right, so it's not as if you could complete Mr. Anya, do you have anything to say to that?
No, the only thing I would like to say is that I'm a bit surprised because before the tribunal resumed, I had a chat with my learned friend just to have an understanding of how we might proceed today. The only issue she raised was that we served her the document yesterday and that she might not be able, and well, she even though she wasn't very certain, but she said she indicated that she might not be able to go, that the trial might not go on. She never expressed any reservations about what to file. So I may be surprised, but that being the case, she's entitled to react. And but I'm really not very clear as to, is she opposing the application?
That's what she says she might want, but she's entitled to respond.
I mean, I'm a bit surprised because we had this conversation.
Mr. Anya, the rules allow a minimum of 2 days.
Yes, which was why when I came, I had a conversation with her.
Have prerogative to change her mind, even if that was the case when you spoke with her. But apart from that, because you see, the truth of the matter, we are here to dispense justice equally. The truth of the matter is she is a civil servant. At the end of the day, I mean, I am sure, just like your clients who have your output, our companies want to look at what goes wrong. If anything went wrong, I think it's only in her best interest to make sure that she crosses all the T's and dots all the I's of her case as well. But now, having left us, she said something, and that's where I said, when you call it a housekeeping application. I don't think it's a housekeeping application. You're introducing a lot of new things.
We are reacting to the new. We are not re-arguing our case, or rather, we are not rehashing the points we made in the notes of our case. We are reacting to the note to her response. Now, admittedly, this is not a proper court, but in a proper court, if a party has filed a defense, the party starting, the claimant, is entitled to file a reply. Now, the rules of the tribunal is not that, has not provided for a reply.
No. The rules of this tribunal allow you to reply. And let me also tell you, in case you are not aware, that the rules of this tribunal says that where there is any lacuna, the rules of the High Court will continue. So since that is the procedure of the High Court, but check the rules. It allows, and it's an everyday occurrence in this court. People are entitled to file a reply. In other words, if you file your own appeal, the person files the defense or reply or response or whatever, you are entitled to file a reply.
And that's what we're here to do.
No. But you know that your reply cannot be at large. When you file your reply, it's limited to some issues.
Well, I don't know if the tribunal is making comments on the application already. We are not.
No, you put it in your application. You said it yourself that you are ready.
That we are not reacting.
Should I read what you put it?
Well, if the tribunal is minded, but if she wants to reply, she can reply.
That is not the issue. I am asking you what you put can help you. Also, this is political. Your paragraph 4.5 in your basic address. It says, in the instance, the facts are that the applicant commenced this matter by notice of appeal dated the 29th of January 2026, along with other accompanying processes. In response, the respondent filed his reply dated the 13th of March, wherein it raised new facts and issues not already addressed or contemplated in the appellant's notice of appeal. Unless the tribunal grants the release of this application, the application would be denied. The applicant would be denied the opportunity to respond to the new facts and should be raised by the respondent. In 4.6, we therefore submit that it is in the interest of justice and fair hearing for this honorable tribunal to exercise its powers of discretion in favor of the applicant by granting the relief sought in the application. Furthermore, we submit that the factual material contained in paragraphs 3 to 5 of the supporting affidavit only and satisfactorily justifies the grant of this application, as it advances the applicant's right to fair hearing and delivers substantial justice to the parties involved. Additionally, the facts are sufficient to meet the threshold for the favorable exercise of this court's discretion, and granting this application would not prejudice the respondent. So, here you are. You said they have raised new issues. You want to respond to new issues. And basically, the point is when you are filing a reply, it's usually on new facts, like you said, and facts of law. But basically, what we have here is that you, in the witness statement, you're talking of Uber not being a hailing service or to marketing. Sorry, it is your fault. You're talking of Uber, then I'll refer you to it. You're talking of Uber, and you attached some documents that you have put in the schedule. Hold on, sir. Sorry, I've just seen the hard copy today, but I know I studied some copy which was forwarded to us as far back as Wednesday.
Well, I think that since the respondents council has indicated that she would like to respond, I think we should not allow her to respond.
I'm glad that was where I was going, because here we have additional list of appellant documents to be relied on. You have an amended, you have the Uber exhibits, exhibit Uber 25, exhibit Uber 26, exhibit Uber 27, 28, 29, and quite a number of other things that you missed. So, like I said, you are independent here, but because it cannot continue. If you now raise new issues and they now have to respond to new issues, where does it end?
No, I'm sorry. You rightly mentioned that we have a right of reply. That reply here is by way of rejoinder. I mean, in terms of terminology, their response is called a reply. So we cannot call our reply a reply again. So that's why we can't do the rejoinder. Now, we have only responded to new issues. New issues.
With all due respect, I've been doing this work for about 46 years. So I have an idea of what they call different documents. If you are talking of the irregular court, there's a claim, there's a defense, there's a reply. In this tribunal, they are quiet about what they call it. So instead of being a claim, since it starts as an appeal, the response, some people call it a reply, some people call it a rejoinder. Ordinarily, it would have been a defense, but because it's an appeal and not, it commences by way of appeal and not by way of a claim. That is why some people elect to call it a reply or a rejoinder or a response. So what you call it does not really matter. What is important to us here is what it, when it comes in and what it comes out in. What you are bringing in could be a reply to their own rejoinder, it could be a rejoinder to the whatever. So that is not the issue. The issue here is you are entitled to reply to whatever the respondent has filed. However, you are not allowed to start new issues that they now have to reply to as well. And that's what we're saying. And if you think I'm wrong, you can appeal our thinking when we move. You haven't moved the application yet. But what I'm trying to explain to you is we haven't taken a position, but let's do things right. You can't knock them out from having the right.
No, I'm not saying, with due respect, sir. I'm not at all suggesting that they cannot reply or respond to that question. Far be it. The only reservation I made was that when we came in, she didn't give me that indication. Otherwise, when the tribunal started, I would have told you frontally that I have been informed by my learned friend that she was wanting to oppose the application.
Anyway, let's not get off on the wrong foot here. You see, my position is this. Like I said, some of us have been doing this for a while. She might have taken a hint from our thinking, and she's entitled to. Because when you said it was a housekeeping application, I know it's not a housekeeping application because we are going to have to sit down. In fact, if she had responded today, we were going to have to adjourn to rule. I wasn't going to give a bench ruling. And the reason is simple. You know very well that it is not every day, otherwise you would not have been applying for leave. Because if it was just the statutory procedural right to reply that you're entitled to, you would have filed it. But what is the issue which you are now looking for leave for is that you are going outside the ambit of the irregular response on matters limited to what she has brought up or issues of law. And what we do not want is a situation you are bringing in new issues. Now, they would now feel obligated to respond to. Then it will never end. I mean, in exceptional situations, that might even be looked into or looked at. But a situation where we don't know what we are going to get ourselves into. I'll give you an example, for instance. For instance, if I was a claimant and I find myself in, I would apply to amend my statement of claim or my appeal. Then you can bring in anything. So what I'm trying to tell you is that there are ways to this thing. So when you sit there and you talk to us as if we don't know the difference between a reply and a response, you're not doing us any favor.
No,
it's not very kind of.
I wouldn't suggest that, and I'm sorry if that was right.
That's the way you come across.
I'm sorry. They are entitled to respond, and my understanding is that this tribunal is a fact-finding tribunal. That's what the courts have held.
No, we are now obligated to follow the Evidence Act.
Yeah.
Under the new rules, under the new Act of 2025.
Yes, I saw that. And in addition to getting to the root of the matter, that's why every party will be given opportunity to present the facts.
That's exactly it. And that was why we said, let us not rush to judgment. If she wants to reply, at the end of the day, I suspect you're getting everything you want to get. There's hardly any likelihood of your evidence being excluded. In any case, I'm just giving you a hint of another way to get in the same thing, even if this is going to be difficult for you. Because at the end of the day, what we want is justice.
That is very appreciated. Thank you so much. I'm a friend of the tribunal. I've been appearing before, even before the formal.
Udoma was my classmate in law school, my very good friend.
Thank you. Thank you. I when it was the Body of Appeal Commissioner, that was when I started appearing before this tribunal. Long ago.
It's normal, you know, when counsel is there, they don't know the tribunal member, they think these ones, they don't know how they got there, they don't know the left from the right. But trust me, I mean, after you've gone through all this, and somebody puts you here 20 years after one fiery your counsel thinks that he wants to show.
No, apart from that.
We've done it before journey, so it's our own common pass school. So
apart from that.
So
thank you.
So Mrs. Belinda Gubo, how long do you want? How much time do you want to respond?
Probably
2 weeks. No. To file, because they might think you're tight. If you are going to oppose and you file your written address, they are entitled to reply in case they want.
As a tribunal, please.
So 1 week, 2 weeks, so that they can have a week to respond.
If I just, like the tribunal, I was able to go through the hard copy. Yesterday, I know it was scanned and sent to me, the soft copy of it. But when looking at it, ordinarily, like I said, I shouldn't have any problem with it. However, if a criminal issue is going to drag us along with this matter, like I said, we will go back and take the best way possible for us, because we don't want a criminal issue like this to drag out this issue. Then we leave the begin to focus on it. That's another way we can look at it. But we will go back and look at the best way possible for us. But we will not allow a criminal issue drag us out.
So
I was hoping the appellant would have just said, okay, can I retwitch? Let's give some other arguments we made, give you for a final address. That's okay by me. However,
how long? 1 week, 2 weeks.
it will take 2 weeks.
Yes, yeah. If you want to reply, fine. 1 week, okay.
1 week is fine.
Is there anything else before we fix a date?
No, sir. No, sir.
No, it's for addresses, but I'm not sure of the date. Thursday, the 4th of June.
That's fine, sir.
Mrs. Oyenaguno.
Sorry, sir. Just to be clear, so I don't.
We haven't given the ruling. I just started out.
Okay.
If there's anything else you want to ask.
I just wanted to make sure that is for the motion, so that my witness doesn't have to join against.
It depends on how you want. Yes, let's do the motion.
Yes.
If you're going to have to adjourn for ruling.
And get it out of the way.
That makes sense. Tribunal. The respondent is to file her processes in opposition, if any, within 14 days of stay, and the respondent is response within 7 days thereafter. Case adjourned to the 4th of June 2026 for argument of the motion. Thank you very much, ladies and gentlemen. Mr. Ayano, I'm good, no hard feelings, trust me.
Thank you so much. And again, if I came across as a bit aggressive.
Yeah, I belong to the 70s, and that's the only set of the bar. No, we set this thing. We set the bar, so no worries at all.
Thank you so much.
Mrs. Chibuzo, no, you are excused for today. I'm sure they'll bring you back on Wednesday. The same goes for the representative of the respondent. So, we will be going on the trial.
Okay, sir.
We have any other? Ladies and gentlemen, that would appear to be our docket for today. This tribunal started on.